And good morning, Your Honor. Joseph Hall appearing for on behalf of Ms. Klosick, who stands to my right. Ms. Klosick, if you could state your name for the record, please.
Samantha Nicole Klosick.
Thank you very much. And Your Honor, at this time, we have executed paperwork, and I've advised my client regarding her rights moving forward. She would elect to waive preliminary examination and proceed to circuit court.
This is a operating while intoxicated causing serious injury.
That's correct, Judge.
And does she have a medical marijuana card?
Your Honor, she has an expired one, and she has an application.
Why is she using?
Your Honor, we don't.
Mr. Allen.
I would not advise her to comment on that. But Your Honor, she does have a doctor who has certified, who has executed the appropriate paperwork, which is sent to the state. We believe that card is in the mail.
I'm going to hear the court's answer.
When was that done?
That was done immediately after she exited Maple Grove, Judge.
Immediately after what?
She exited the inpatient facility where she was in between the last hearing and today. So we do have some documentation, Your Honor, from the doctor's office.
When did she get out of the facility?
I have precise dates in my phone.
I went in on the 6th.
Yes, I believe it was the 22nd. Well, her appointment with Dr. Durinka was January the 22nd, Your Honor. So at that point, she was out of the facility.
When did she go in?
The 6th.
The 6th of January.
Came out the 22nd.
Your Honor, it was close to, without going back to my file, I don't want.
That's fine.
Okay.
All right, everyone, get ready for this. What happened in that courtroom was raw and unforgiving. Samantha Clay faced serious charges, driving under the influence and injuring someone. Her defense? An old, invalid medical marijuana card and a last-minute note from a doctor. The judge wasn't buying any of it. From rehab records in Maple Grove to drug tests and unclear paperwork, nothing could cover the facts. The truth was clear. She had been using, and the court knew it.
And then is using.
With Dr. I understand, Your Honor. I mean, I'm not going to dispute the drug test.
Counsel approach.
Yes, Your Honor. Thank you, Your Honor.
All right.
Your Honor, I appreciate the bench conference in this matter. At this point, while we have a lot of what I would call circumstantial evidence of what we've already said, that there's been an application made, we believe it's going to produce a card. We understand Your Honor's position that right now, technically, we're in a legal gap there. And we understand the results of the test. We do not dispute the results of the test. I would ask for the shortest possible adjournment. Ms. Klosick was being tested while in the Maple Grove facility. We're going to get those test results and forward them to Your Honor as soon as possible.
Once I get those, I will reconsider the decision I'm about to make now. But given the nature of the charge in this case, with operating while intoxicated causing serious injury, she's using. Prior to her going into treatment, there's cocaine and 2 other drugs in her system, comes out of treatment, and now I still have another drug in her system that cannot be tolerated and won't be by this court. So at this point, I will adjourn the probable cause conference to February 6, 2025 at 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
And Your Honor, one more point. I do have a letter from her medical doctor regarding her future testing, stating the basis for a recommendation of swab testing. I can provide that to both Sister Counsel and Your Honor for when eventually she is released, and we're going to.
Well, if you hold on to that, then I'll certainly address it next week.
I'll send this with the test results, Judge, to all parties.
That'll work.
Thank you, Your Honor.
All right, thank you.
Let's be clear. This judge wasn't in the mood to show mercy to someone still making excuses. After leaving treatment, Samantha Clay failed another drug test. Cocaine showed up this time, along with other substances. And once again, she had another excuse ready. But the judge didn't hesitate. Her bond was revoked, and the case was pushed to February 6th. Samantha didn't walk out free. She was taken into custody on the spot. This wasn't recovery. This was pure refusal to change. And everyone in that courtroom saw it.
Andrew Childers appearing on behalf of the people. Assistant Public Defender Jay Bellinger on behalf of Mr. Washington, who appears to my right. Mr. Washington, can you please state your name for the record?
Marcus Wellington. Thank you.
Your Honor, we are currently trying to work out a resolution on this matter. I have talked to Mr. Childers about that. We'd asked to set this matter for preliminary examination at this time, and I would ask for a bond argument when appropriate.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 11th.
Yes, Your Honor.
Preliminary examination in person, February 11th, 2025, 9 a.m. That is before Judge Valvo. As to bond.
Thank you, Your Honor. As to bond, my client's current bond is set for $25,000, 10%. He informs that he can stay at the Delano Center. My understanding that the bond was set so high because at the time he was out on bond for a different matter before Judge Bob. I'm sorry, it was not Judge Washington, Judge Perry. At the time, it's my understanding that when he caught these charges, that was a result of a violation on the other case. He caught a DV charge.
Next up was Mr. Washington, adding more trouble to his already long list. He showed up in court facing new charges while still out on bond. Hoping for a break, his lawyer argued for a personal recognizance bond, saying his earlier domestic violence case had been dismissed. But the judge wasn't convinced. Why? Because getting caught resisting arrest while already violating bond conditions is a serious warning sign. The judge shut it down immediately. No bond reduction, no second chance.
Without prejudice, I'm asking for a bond in this case, a PR.
Were the police trying to take him into custody on the violation of the other matter?
They did, Your Honor. That case has since been dismissed.
I understand that,
Yeah.
but that's what led to these charges?
Yes, Your Honor.
Of resisting and obstructing a police officer?
That's my understanding. Your Honor, my client advises he's been in custody for the last 2 weeks, that he has a job that he will lose if he's not able to leave.
I understand that, but that can't be allowed where he picks up 3 R&Os. You're just trying to take him into custody on a valid warrant, regardless of what the consequence of the charge was.
I understand, Your Honor.
I don't need a response from the people. Most for bond reductions denied. Bond will continue. Call the case of the people of the state of Michigan versus Robert Heft.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people. Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Heft. Mr. Heft, can you state your name for the record?
We are getting him right now. We might not be able to do it.
Is that Mr. Heft?
Yep.
All right, defendant is present. Go ahead, Tom.
Your Honor, I received a report stating that Mr. Heft was incompetent and not restorable within the time frame. I would stipulate to the court and did prepare an order to the court for signature regarding that.
And will not, and is not restored.
Stay with me. This part gets intense. Robert Heft was officially declared incompetent to stand trial, and the court didn't see any chance of that changing. His public defender confirmed it, and even the prosecution didn't argue. The case had already shifted to probate court. The judge made it official and moved on. But from the bench, Heft suddenly yelled out, "I'm not incompetent." It was a raw, chaotic moment in an otherwise routine hearing.
It's not restorable.
All right. Any response from the people?
No, Your Honor, I am not able to get into the county system this morning, but I would not dispute Ms. Apple's representation.
That is what the report reads. The defendant is found incompetent. How are the people going to proceed?
So there's an option on there that we file a petition, and so I need to review the file to see if we will file a petition for commitment.
All right. So what I will do is
I think check it and we'll get it filed.
all right. Well, the question is whether I set a new date so that we review it. Otherwise, it's going to sit there if something falls to the cracks. So why don't I How long will that take you think?
Excuse me?
Yes.
Hi. Sorry, I work here in the court office where Mr. Heft is hospitalized. I just want to let you know we have already completed the petition and certs to probate him. So it's already been completed with Washtenaw Probate Court.
Oh, fantastic.
Then my office won't file a petition. Thank you.
All right, then what I'm going to do is I'm just going to find him incompetent. And we'll continue, and you'll have to at some point send an alley process.
Yes.
No, I suggest you go back to school there, Judge. I'm not incompetent.
Okay. Thank you.
The letter, or do you?
I'll do that this summer. All right, thank you, Mr. Heft.
Yesterday for Ms. Johnson to resolve all three.
The tension in the courtroom shot up fast, but the judge didn't hesitate. Heft wasn't restorable, and the process had to move forward. The system doesn't pause for emotional outbursts. It keeps going. All the paperwork for probate was already in motion. No delays, no chances to slip through the cracks. The judge's ruling came fast and firm. Competency isn't about what someone claims. It's about official evaluations. And for Heft, the door closed right there in that courtroom.
If we can go out 1 week, then I'm confident we can bring it to her and close these 3 files out, Your Honor. Apologies. Yeah, we have a good offer. Just need to get it to her.
No objection.
Probable cause conference, February 6, 2025, 9 a.m. Bound continued.
Thank you, Judge.
Thank you, Cedric.
Thank you.
Thank you. See you, sir.
Yes, ma'am. I'll be able to see you.
At least she knows you by first name. No, that's good. I'll answer to most things. Court calls case. We need her attorney. I think that's Miss Cannon. I realized last Thursday was rough, but she needs to appear today.
I apologize, Judge. I can stand in if there's something resolved.
Mr. Childers is in Zoom, so it's hard to have that conversation. Is Miss Cannon here?
Yes, Judge, I apologize.
She's in the block.
Does she want to stay?
You need me.
Right. Why are you come? Did I say yes?
Oh,
Did I?
may I approach? Just for,
You're up here now. Just. I'm not gonna. Why did you just hold on? Just stop.
Go off for Good morning, Judge.
Then came the chaos. Miss Brock showed up late, almost missed her hearing entirely. She was just minutes from being skipped when she finally walked in, shifting the courtroom's focus. Her lawyer scrambled to catch up, quickly giving updates, while Mr. Brown managed to buy her a little more time. But here's the real issue. A second OWI charge had just been filed. Promises about progress on probation weren't enough. This courtroom doesn't deal in promises. It deals in facts. And now, her case is being sent over to circuit court.
I didn't even say yes. He all up in my face. All right, ma'am. I'm going to wait for your. She's back in lockup talking to another client, so I'm going to pass your matter briefly, and we'll get you called up momentarily. Okay?
Thank you.
Thank you. Oh, now she's here.
I'm sorry, Your Honor.
No, perfect timing. No need to apologize. So why are you going over there?
Ms. Brock, yes, Your Honor. Thank you. Stephanie Cannon appearing on behalf of Ms. Brock.
All right, Ms. Brock, can you state your name, please?
Lastasia Brock.
Thank you.
Thank you, Your Honor.
You need to thank Mr. Brown for Mr. Brown covered for you. He was all up here at the bench. He was buying you all kinds of time.
Thank
But
you.
go
I
ahead.
appreciate that. Your Honor, a lot has happened on this case. The OWI second that the court was waiting to be filed, I believe, was authorized on the 28th.
Okay.
So that charge has now come to light. My client is wanting to wait to see if she can get a global resolution on this case. I did email Mr. Childers. She's doing exceptionally well currently on probation. I believe that this case is resolvable short of trial, but she wants to waive over.
To circuit. All right.
Yes.
Ma'am, pretrial in this matter will be set for March 31st, 2025, 1:30 before Judge Hammoud.
Thank
March
you, Your Honor.
31st.
I'm sorry?
March 31st.
Yes, March 31st.
Okay, thank
Great.
you, Your Honor.
A great day.
You too.
Yeah. Bond continued.
Final word. March 31st, pretrial in circuit court. Miss Brock claims she's doing great, but the reality tells a different story. Her charges keep piling up, and the court's watching closely. Time is running out, and the judge's patience is wearing thin. This isn't a place for feel-good speeches. It's where actions matter and consequences hit hard. From revoked bonds to incompetency rulings, this courtroom made its message clear. Clean up your act or end up behind bars. No excuses. No second chances.